We had discussions with folks from the Pennsylvania Utility Law Project that have to do with social justice themes, that have to do with obtaining services to be able to obtain a house. And so when I look at that, I go right to the Pennsylvania Human Relations Act and talk about, well, what are services that are involved with securing the home? And obviously utility comes into the, and so our discussion has been very interesting. I want to welcome and thank both Ria Pereira and Lauren Berman for taking the time and providing this training. I'll remind that if you are not going to be speaking, that you maintain yourselves off mute unless you want to ask a question when we get to that portion. Yeah, this is going to be great. And with that, I'm going to go ahead and let the ladies take over.
Great. Thanks so much, Adrian. And both Ria and I are, of course, very happy to be here to sort of provide you all with some hopefully useful information. I'm going to start sharing here. Let's see. Bear with me. There we go. Okay. So, as we've said, my name is Lauren Berman. I'm an attorney with the Pennsylvania Utility Law Project. Ria Pereira is our supervising attorney with PULP. And so we're going to go through some basics of utility law. I will say at the outset, utility law is very dense and very niche. So what we are doing here is touching on things that are likely to come up as you are speaking with people who have filed complaints, people you may be dealing with as you're doing outreach events. So just to get you enough information to sort of know when something might be an issue and where to go, who to reach out to, who to look at for resources. So just a little bit of level setting there. We're not expecting anyone to be able to provide, legal advice on utilities, but to at least know that, oh, this it's going to ping something, right? So a little background on us. So we're with the Pennsylvania Utility Law Project. We are a statewide legal aid office. We are a project of Regional Housing Legal Services, who do sort of larger scale housing work. Our mission specifically is to secure just and equitable access to safe and affordable utility services for Pennsylvanians experiencing poverty. We do this in many ways. Legal representation. I personally work on a lot of our direct services. So we do have a hotline. I'll talk a little bit more about that at the end when we talk about available resources. We do also do group representation where we will intervene in rate cases, which is what all the regulated utilities do when they want to raise rates. They have to file and request that. So we intervene in those proceedings as well. We do education and training like this. We do policy advocacy. Anytime anything comes up that we think, we could make some headway on, we're pretty, willing to jump on it. Supportive services and consultation or technical assistance, which, we are offering to you all, of course. And again, we'll talk a little bit about the best ways to get in touch with us and when and how. So our agenda for the day, we're going to talk about Pennsylvania's utility landscape. Ria is going to cover most of that, sort of give you an idea of why we think what we do is so important and how large the need is. Then we're going to cover the available assistance programs, both the utility run programs and other federal and state available programs. So, good referrals for people that you're working with. We're going to talk about some of the rules and regulations around terminations and reconnections. We're going to talk about how to avoid termination, which is always the goal. And then we're going to talk about some specific special circumstances, and that'll be tenancy, some immigration issues, just the things to know that there are special guidelines around. And then we're going to talk about disputing bills on behalf of individuals or explain to them that that's a thing they can do. And then we'll give you a list of the available referrals and other resources. We have a lot of good links for you. And then of course we'll do a Q&A. So if you have questions that come up as we're talking, feel free to put them in the chat. We may or may not get them right away, but should have time at the end to address everything. So throw your questions in there while you're thinking about them. We'll hit on them. And again, if we do run out of time, you'll have contact information, so you can always feel free to follow up after the fact. And with that, I'm going to hand it over to Rhea, who's going to talk a little bit about utility insecurity in Pennsylvania.
Thanks, Lauren, and thanks everyone again for inviting us out. And yes, let's talk a little bit about the need related to utilities and utility insecurity in the Commonwealth. So to give you guys a more current snapshot, there is over 320,000 Pennsylvania households who are experiencing involuntary either gas, electric, or water shutoffs as of 2022 as a result of non-payment or inability to pay their utility bills. And then over 10,000 households in the Commonwealth were also without safe heat as of February 1st of this year. Now, of the Pennsylvania households who are experiencing utility insecurity, there is a disproportionate amount of those households who are low income and specifically confirmed low income. So, for example, confirmed low income customers carry 50% of all residential electric debt and 30% of all residential gas debt. Now, we've provided you some other really good statistics here on this slide. What I'll highlight is there is a large number of both estimated low-income customers as well as confirmed low-income customers. So those customers that the utility company has verified that they are low income. There's almost 2 million estimated low-income customers for those regulated utilities reporting, and there is more than 1 million confirmed low-income customers across electric and gas regulated utilities. Now, of those customers and those high numbers of both estimated and confirmed low-income customers, there's only a small portion of those customers who've been able to find and make their way into customer assistance programs, which we will be talking about a little bit later in this presentation. So only about 23% of electric and 22% of gas estimated or confirmed low-income customers have been able to enroll successfully in that customer assistance program, in that CAP. Now, even amongst low-income customers, there are deep and troubling disparities related to socioeconomics and to demographics. So low-income customers can pay 30% of their incomes towards home energy costs. Compare that to middle-income households who are generally seen to pay between around 3 and 4% of their monthly household incomes by comparison. Now, water and wastewater burdens have monumentally increased in the last decade, 2 decades within the Commonwealth. And while they used to make up a smaller portion of people's monthly bills, we're regularly seeing water burden levels that exceed 10% of household income. So really a very steep increases even with those water and wastewater burdens in people's monthly bills. And as I mentioned, there are demographic disparities within these low-income populations. So we do see data that Black, Latino, Latinx, and Indigenous households have significantly higher energy burdens compared to white households. We've given you some really good and striking statistics from ACEEE. So for example, the median energy burden of Black households is estimated and has been calculated at 43% higher than that of white non-Hispanic households. Meanwhile, the median energy burden of Hispanic households, it has been calculated as 20% higher than that of white, again, non-Hispanic households. Meanwhile, if you're looking at Indigenous populations, the median energy burden of Native American households is calculated as 45% higher than that of white non-Hispanic households. So really striking statistics related to the disparities in utility insecurity and utility access. And we know from various sources, the one we've cited here is the U.S. Census Household Pulse Survey, that households do forgo other important necessities to pay for their energy bills. And this can include food, medicine, other housing costs are all commonly cited as those other necessities. So if you look at this in comparison, for example, about 19% of households reporting less than 25K in income are reporting that they forego these necessities almost every month, compared to 3%, so much less, of households with income at or above 75K. So really striking the percentages of households who have those lower, and especially the lowest end of the poverty scale, incomes, and how they're really honestly making those untenable choices to make ends meet on a regular monthly basis. And then again, even within the sphere of low-income consumers, low-income customers of utilities, we do see deep, troubling disparities between demographics. So, for example, you have difference a little bit over, it looks like 15% of solely white households reporting that they're reducing or foregoing certain necessities to pay for energy costs. By comparison, there's almost 40% of Black or African American households alone are reporting that same struggle to forego certain necessities in order to afford energy. And I'll just highlight one more in terms of the American Indian or Alaskan Native, so those indigenous populations, are reporting around approximately 35%, again, in comparison to the much lower white alone, as well as the overall number that sits around 20%. So you're seeing those deep disparities. Again, here, this has been something that's been conducted by on a kind of national level by the U.S. Department of Energy. And then we've been giving you a lot of numbers and a lot of troubling data about utility insecurity, but let's connect that a little bit to the everyday consequences of utility insecurity and really being unable to access utilities on a consistent and affordable basis. So we know, and it's been perpetuated as a result of the recent pandemic, that there are deep health consequences and health outcomes that stem from loss of utility services and utility insecurity, including the possibility that households are without unhealthy or living in unhealthy temperatures, I should say. Either, we look at the summer months where temperatures can push very high and homes become unsafe as a result of that. And then you look at the opposite end of the spectrum when households become too cold to be habitable in the winter. We'll be talking a little bit more about the winter and some additional protections for customers of those larger utilities, those regulated utilities, but absolutely something that can cause housing instability and negative health outcomes, I should say. And then I'll just highlight a few more utility insecurity buckets. There's absolutely family consequences to children within the households. We often, unfortunately, see CYS involvement, custody disputes that can be stemmed from utility issues or if utilities are being turned off in a household. And then if there's no electricity, if there's lack of access even to things like broadband services, it can disrupt child learning and development. Even if, for example, a family has to leave as a result of displacement, that can obviously have negative repercussions on children's ability to learn and develop. And then really how the children in the household might be able to continue to access things like school, how adults can continue to access work. These are all things that can be impacted by utility insecurity. And then there's longer term financial impacts, right? So we often see long-term impacts on credits, especially if there's older debts that might be referred to collections. There's some possible lien issues if you're dealing with a municipal utility that might encumber property and cause housing instability. And then, as I've alluded to throughout the slide, the destabilization of housing. So utility insecurity is often, we see it all the time, cited as a main reason for evictions, foreclosures, as well as homelessness. It can result in condemnation to properties. And really, if we're working with any population, but particularly low-income populations, the difficulty around relocating, especially if they're relocating within a service territory and they're carrying certain debts with them. And we'll talk a little bit about that later in this presentation as well. And then if they're carrying certain debts, they have that past utility non-payment history, they might find themselves in a position where they're ineligible and unable to access either public or private housing subsequently. So really putting these households who are already struggling in an even more untenable situation, if you will. Now, Lauren's going to take us into a really great discussion about some utility-run assistance programs. But prior to that, I wanted to spotlight the difference between regulated and unregulated utilities. And I'll tell you why in a second. So regulated utilities are those utilities who generally larger, but you're looking at those electric, natural gas, and water companies that are under the jurisdiction of the Pennsylvania Utility Commission. Now, as a result, consumer complaint issues can be filed directly with the PUC. We'll give you some information about this later in the presentation as well. And as a result of being under the PUC's regulations, they have to follow the rules, the regulations related to billing, collections, and terminations the PUC has set forth. Now, as a result of these regulations, these larger utilities, generally larger utilities, have to also establish these customer assistance programs. So with these programs that we're going to be talking about in a second, you will generally find them housed within the regulated utilities. It's fairly rare for unregulated utilities to have versions of these programs. It's not unheard of, but they definitely do not come close to the level of development as these regulated utility programs. So generally, when we're talking about these programs, unless we differentiate otherwise, we're going to be talking about the regulated utilities. So just some information really quickly on the flip side of this coin, right? So those unregulated utilities. Generally, when we're talking about these, we're talking about those municipal utilities, those electric co-ops. Now, the exception to this that we often give is the PGW and PWSA. So PGW out in the east, PWSA out in the west are two utilities that are falling in this bucket in terms of like municipal utilities, but they are regulated. They are under the jurisdiction of the PUC. Now, with unregulated utilities, because they are not under the jurisdiction of the PUC, consumer complaints have to be filed at the Court of Common Pleas level. There is less regulation, less statutory requirements is probably the best way to say it, that these utilities have to follow. However, that's not to say that there is none. So there are certain standards under the Water Service Act, under USTRA, which is the Utility Service Tenants' Rights Act, and some other broad consumer protection laws. And we'll be talking a little bit about this later as well. However, there's no standard billing, collection, and termination kind of standards or rules and requirements because they are not under the auspices, jurisdiction of the PUC to follow those rules that the PUC has promulgated. And at the same time, as I mentioned, there's no requirement to offer assistance programs or payment arrangements. So if you take nothing from the slide, take that you should apply these to the regulated utilities, what Lauren's about to talk about, unless we specify otherwise.
Yes, good note. Thank you, Ria. One thing I will say briefly before we move on to some of the specific programs that are available is where this intersects very directly with what you all do is if you mapped the neighborhoods in Pennsylvania with the highest rates of terminations and highest levels of debt, they would map really right onto the red line neighborhoods that I know you all deal with as you're working on fair housing and larger policy concerns. And, you know, those reasons are many. And most of them, again, are probably very common sense to you all. It's, you know, disinvestment, poor housing stock, lack of available housing stock, is the quality of low-income housing generally. So, you know, again, it's the core of these problems are very similar, and it's just they manifest themselves, across the board. So with that said, so going into the utility run assistance programs, like Ria said, these are programs that are run by the utilities themselves. The guidelines for the program are laid out and approved by the Public Utility Commission. Oh, I had the wrong one. So we'll start there. So first thing we'll talk about very briefly is just establishing service. So this is someone is moving to a new service territory, or they're moving from house to house in the same service territory, or they're getting their first house by themselves. They're trying to set up gas, electric, water. So here are the requirements. And again, these refer to regulated utilities. Mileage may vary with the unregulated. So basically all you should need is a name, an address for service, and valid IDs for each adult occupant. They are required to allow photo IDs from foreign governments, including green cards, arrival departure records. And if they don't have a government issued photo ID, you should be able to provide 2 alternative forms of identification, as long as one includes a photo. And utilities may ask for, but they may not require social security numbers. This is something we do run into from time to time. We do provide a lot of feedback on the forms, on the applications, to make sure that it's very clear that those are not required. But that is a good area that if you are running into issues like that, that would be a reason to either reach out to the utility directly to say, hey, you're not allowed to actually require all this stuff, or to reach out to us. Other potential barriers you may see would be debt from previous residences. Sometimes that has to be paid, or it has to be managed in some way before that person can establish service. We'll talk about all these details. And also security deposits can sometimes be a significant financial barrier to establishing service. We'll talk about some ways to work around that. So utility run assistance programs generally, and Ria covered most of this, all the regulated and gas and electric utility companies are required to have universal service and energy conservation programs. That is a term of art. Universal service and energy conservation programs. That is a chunk of regulations and programs that they're required to offer. Most large regulated and water and wastewater utilities have some variations of these programs. They're getting better over time, but they're not quite at the same level of development as the gas and electric are. And then there are some municipal and sewer authorities that may have some small programs. They may have small hardship funds or specific policies around payment arrangements, things like that. But it's really whatever they feel like putting together. So these are the main components of the assistance programs run by the utilities. So a customer assistance program, we refer to it as CAP. That's sort of the legal term. Some of them have other names, but they are all CAPs. And they provide reduced bills and arrearage forgiveness, hardship funds, which are grants available to pay past due bills, again, housed and funded largely by the utility companies. A low income usage reduction program, that's where we run into a lot of those issues around poor housing stock and disinvestment, where low income households tend to have a lot of issues with insulation, good windows, that kind of thing. And then the customer assistance referral and evaluation services, CARES, and these are sort of subsets of customer service reps at the utilities that have some additional training regarding specific circumstances to help with case management and referrals to other social service supports. So CAPs. So CAPs are the big one. CAPs are sort of the largest part of these assistance programs. They provide lower monthly payments, usually capped at a percentage of household income. So when we talk about those energy burdens, the percentage that a household is paying for heat or light or water, this sets that at a cap. And that depends on household income. Not every company does it that way, but most of them do. And I think we're sort of pushing to get the last remaining couple to do that. Past debt forgiveness. So if you enroll in these programs when you have a bunch of debt, they take that whole debt, freeze it, which means they don't collect on it. And then every month that you make a cap payment, you get a percentage of your debt forgiven. So it's not a payment arrangement. It's a completely different thing. A lot of people will get that confused, especially if a lot is going on, but it's not a payment arrangement. You do not have to pay towards it, but you do need to make your CAP payments in order to get that forgiveness. And the CAP payments are designed theoretically to be affordable. Eligibility requirements, so annual gross household income at or below 150% of the federal poverty level. So just by way of example, for a household of one, that would be $21,870, although these are going to go up a little bit in the new year. And then for a family of four, you're looking at $45,000 per year. So that's just to give you some idea of the income level. Active customer service has to be on. Sometimes utility companies will turn someone back on if they're CAP eligible so that they can enroll. But those are exceptions that they make when we advocate for that. That is not something that they're just going to volunteer to do. So typically speaking, your service has to be on. They will require periodic income verification. That depends on a lot of factors. It can be anywhere between every 6 months to every 2 or 3 years. It really just depends. But a lot of people get removed from CAP for failure to recertify. So if someone had been paying, their CAP bill and it's $45 a month, and then all of a sudden they get a bill for $360, they may have just not recertified and sent in their income verification. So that is the thing that happens. And then again, to enroll, a lot of those forms still ask for social security numbers, but they should all specify that they are not required. So hardship funds is sort of the second chunk here. So these are typically up to $500, one grant per year per household to resolve a crisis. What that means in the utility space is that they either the household has a shutoff notice, or their service is already off. The tough things with the hardship funds is that if someone is at the point where they're getting shutoff notices, typically they owe more than $500. Not always, but sometimes they do. And these grants really have to solve the problem. So unless that money is going to get someone back on, they're not going to qualify for that grant. That said, it can be combined with other things. Maybe it's $600 and the client can make a $100 payment. Great, good enough. Or during LIHEAP season, which is right now, and we'll talk about LIHEAP, that can be combined with a crisis grant to get to whatever dollar amount they need to get their service back on. So again, these are areas for advocacy. These are sort of the starting points, but there's work to do there. The grants are funded every year on October 1st and just go until the money runs out. Some of the utilities don't run out of money. Some of them, if they do run out, it's usually going to be like July, August, September, like sort of around that time of year. And they're usually administered by Dollar Energy Fund or other community-based organizations. Eligibility for hardship funds is a little bit higher than eligibility for CAP. It's up to 200% FPL. This is sort of meant to be like sort of gap funding, where there needs to be some assistance for that income level, but not the full suite of assistance that a CAP provides. I don't particularly agree with that, but that's sort of what it is. So they can also, a lot of companies have what's called a sincere effort of payment requirement, meaning that someone needs to have made a payment of either 3 CAP payments or $150 over the last 90 days. It's usually something like that in order to qualify. But the company also, again, can make exceptions. They'll typically want some extenuating circumstances, a death in the family, an illness, something like that, or some temporary hardship. So again, these programs they're good. They're not a hardship fund is not generally going to solve someone's underlying issue, but it's a good sort of temporary help from point A to point B. Low income usage reduction program. So these provide energy audits. So the company will send someone out to do an energy audit of the home and see, are there major issues, are there minor issues, and then they can provide appropriate conservation measures. At their simplest, it's, maybe, I don't know, caulking some windows and replacing light bulbs, but it can also include new appliances. So a new water heater, a new furnace, a new refrigerator, things like that, all free of charge. The income level, it depends on the utility. It's either going to be 150% federal poverty or 200. Again, I think for the ones that have it at 150, I do think they have a chunk of funding for the 150 to 200, but there need to be some extenuating circumstances there. Landlord approval can definitely be a tough one. They're supposed to make it easy. They should be able to do it over the phone, or there's a brief form. So it shouldn't be a burden, but the landlord would need to approve of any work in the home that includes, again, replacing appliances that the tenant doesn't own. CAP customers may be required to participate in LIHRP. However, if a landlord won't cooperate, I've not seen someone get removed from CAP for that reason. So it's not like they have to, move heaven and earth to get their landlord to sign off on something. There are several other sort of levels of weatherization and conservation programming out there. So they also have internal Act 29 programs, which are very similar to LIHRP, but are funded differently. There are also county level weatherization providers. There's a link to the list of those. So they will be coordinating. So if you try the utility company first if you think someone can benefit, because they're typically much quicker at getting someone out there. But if they need things beyond what that limited program can do, they should be coordinating with the county level weatherization providers. And then CARES. So CARES doesn't get used very much, and the usefulness of the CARES team can vary wildly from utility to utility. But if you have someone who you feel like needs more explanation of their bills, a little more assistance, a little more guidance, just to sort of keep everything clear and what needs to be done, CARES is a good first step. And also, if you have someone that has a disability, for example, if they are a person who is blind or they are a person who is hard of hearing, if they need specific accommodations so that they can access their bills and information easily, CARES would be a good first stop for that to request the accommodation. And then let's see, we'll talk about, so that's the utility run assistance program. So those big chunks of things. There is other assistance out there, not as much as there was during the few COVID years, but there is still some available. So weatherization, which I talked about, they will generally work in concert with the utilities LIHRP programs, but the eligibility is a little bit higher income-wise. They do prioritize for higher need or high risk households. You do have to be a Pennsylvania resident, landlord permission. Again, that's largely a contractor requirement because they can't do work on a house if they don't have permission from the owner. These sort of services are slowly expanding to multifamily buildings. Right now, it's primarily standalone homes, maybe duplexes, but it's really individual homes. Health and safety deferrals are an issue that come up. Sometimes the condition of the home is such that the weatherization measures that they can provide wouldn't really help. Like, they're not going to replace the windows if there's a hole in the roof because they're not going to get any benefit from that. So there is a deferral program designed specifically to help with those kinds of major issues. Or, for example, sewage in the basement is another one that comes up fairly frequently. They're not going to do work in the home if it's not safe. So again, this is the link to county agencies. So then they have contact phone numbers, emails, individuals, like you can find a person to talk to. So just know those are really useful, can be really useful referrals. The big assistance program is LIHEAP, and you all are probably slightly familiar with LIHEAP. So LIHEAP is a federally funded home energy assistance program administered in Pennsylvania by the Department of Human Services. It opens November 1 every year. And this year will be open until April 5th, which is not as late as we would have liked, but it's open until April 5th. It's a grant program. You have to apply every year. It's not CAP. People get those confused a lot because they're both, people should be accessing both things. Sometimes they get sort of stuck on one or the other. So you have to apply every year. There's three main components. There's cash grants. So that's available they'll be anywhere from $300 to $1,000, and that the dollar amount is going to be based on the household size and income. A crisis grant is available to resolve a home heating crisis. We'll talk about what a crisis means for LIHEAP. And the grants can range from $25 at a minimum to up to $1,000. So you get what you need, and you can have 2 crises. So if you need a grant in the fall and a grant in the spring, as long as you haven't met that $1,000 limit, you can access that twice. It's not a one or done. And then they provide crisis interface, so emergency furnace repair and replacement. The way to apply for that is on the actual LIHEAP application. There is a checkbox for my furnace doesn't work. They should be able to get someone out to fairly quickly. They may not be able to do the repair or replacement right away, but they are required to make sure that the family is safe, and that so they may either provide additional heating. They'll make sure they have another place to stay. They won't provide funding for that, or they'll provide, blankets and other temporary heating until they can actually do the replacement. To apply for LIHEAP in person at the local county assistance office, apply online through PA Compass. That's where people sign up for other state benefits like SNAP. Compass or in person are going to be the quickest ways to do these. But if someone doesn't have internet access or has limited mobility or lack of transportation, they can call and just have a paper application sent to them. The county assistance offices should make it easy to apply. They should be working with you to get them, get those applications in. And then so eligibility for LIHEAP. So general eligibility, it's the same as the CAP programs. It's 150% federal poverty. You have to have a home heating responsibility. The most common way is that you have a bill in your name. If you have the bill in your name, you have a home heating responsibility. But even if you don't have the bill in your name, you may still qualify for LIHEAP. Most people will qualify for a LIHEAP grant. There are limited circumstances in which they will not, and that can be. I think the one main exception is if you pay utilities as part of your rent, meaning you don't pay the utility bill, you don't pay the utility directly, and you don't pay the landlord a specific amount. It's included in your rent. And your rent generally is set at 30% of income. So in subsidized housing, for example. So if your rent is set at a percentage of your income and you don't pay separately for heat, you would then not have a home heating responsibility. But most other circumstances, people will. And then a PA resident. So for crisis, you also need an actual or an imminent home heating emergency, which means you either have a shutoff notice, your service is off, or you have 15 days or less of deliverable fuel oil. So LIHEAP will pay a delivery company for a delivery, and the grant has to resolve the crisis. Sometimes people's debts are higher than what they can get from LIHEAP, and that is an avenue for advocacy with the company, and you ask to make the exception. Often they will, but it does depend on individual circumstances. And then additional eligibility for furnace repair and replace. It has to be broken. You can't just not like it. The home has to have been purchased with a working heating system. So you can't buy a home in July that doesn't have a functioning heating system and then apply for LIHEAP in the fall and request a new heating system. And the furnace has to have been operational within the last 2 years. And here's something that may intersect with your work a little bit, so we wanted to highlight it. So the LIHEAP for immigration status. So both U.S. citizens and non-U.S. citizens may qualify. A qualified non-citizen could be anyone under this list here. There's also, we have a link to the state plan, the LIHEAP state plan at the end of this. The appendix to that gives a full list of eligible immigration status and acceptable documentations. For a person who is a U.S. citizen, a statement that they are a citizen is considered sufficient. If for someone who is a non-U.S. citizen, they do have to provide documentation from immigration. And again, the list of full status and acceptable documentation is available. For mixed status households, a household member who does not qualify due to their immigration status can still be the payment name for the household, right? Like if you have a mom who doesn't have a qualifying immigration status, if her kid was born here and is a citizen, that household can still qualify for LIHEAP. But the mom, however, will be counted as a household. She won't be counted as a household member, but her income would count. So that does disqualify some people. So again, this can get sticky. So questions, always feel free to reach out, but just know that you do not have to be a citizen to get LIHEAP. You do not have to provide a social security number, although they will ask for it. There's a separate form, the energy assistance affidavit, that can be completed with your LIHEAP application if you do not have or do not want to provide a social security number. And I think at that point, I will pass it back over to Ria, who's going to talk a little bit about terminations.
Thanks, Lauren. And that's exactly right. Let's talk about when a customer for utility is facing utility disconnection involuntarily, or as we call it, a termination. You can go to the first slide of the section. Thank you. So utility terminations can occur for a number of reasons, but the one that you're going to see time and time again in the utility world is a termination as a result of non-payment of an undisputed delinquent account. So someone who's unable to pay on an undisputed delinquent account on amount is facing termination. And the undisputed here is emphasized because we're going to talk at the tail end of this presentation about what happens if there is a dispute on the table and how that potentially might stay termination. So termination can occur for a number of other reasons that we see with some frequency: failure to comply with terms of payment arrangements or payment agreements, failure to complete a security deposit, failure to permit access to equipment, or possibly a tampering issue with equipment, which becomes really hard to kind of navigate and potentially litigate if it goes that far. Some rules of the road, if you will, related to utility terminations. Terminations can only occur Monday through Thursday. No Friday terminations, no holiday terminations. So keep an eye out for those dates that you see on utility notices of termination. So let's talk about some of the requirements of those notices when those, at least those regulated utilities, send out those notices. So utility termination notices, there is a 10-day written notice requirement. So essentially the regulated utility has to send out that written notice at least 10 days prior to a termination. However, the notice is valid for 60 days. So that 10-day to 60-day period is that valid period you're looking at. In addition, there is a 72-hour requirement that the utility attempt, keyword being attempt, personal contact with the consumers. Now, personal contact doesn't necessarily mean in this context face-to-face. It can be an attempt to contact a customer either in person, but also by the phone or electronically through email or text. Now, this does require customer consent in order to send this electronic notice. However, think about all the things that you might have signed on as you were signing up for utilities or other similar services. You might not necessarily remember that you consented to this electronic notice. Same with the customers that we help out as well. They might have consented to this at the outset of their service and might not necessarily remember. So there is also a requirement immediately prior to termination that we call the last knock, which literally means that there's an attempt at personal contact at a residence immediately prior to termination of service. Now, keyword here being attempt. If the attempt is not successful, it doesn't necessarily stave off termination. However, if you're working with a victim of domestic violence, so we'll talk about this in a few slides, but it's victims of domestic violence that have certain documentation that the utility has on file. If the attempt is attempted but not successful, the utility has to go away, post notice, and come back in at least 48 hours. So there's an additional notice provision for certain survivors of domestic violence. So winter moratorium, I feel like I alluded to this at the beginning of the presentation when we were talking about utility insecurity. because of precipitous low temperatures that can occur during winter months, at least with those regulated utilities, low-income households are protected from termination from December 1st through March 31st. Now, as I mentioned, this is regulated, so it's going to be those regulated gas, electric, and heat-related water services. So if you're working with someone, for example, with radiator heat, this would be under that kind of auspice. Low income here means households at or below 250% at the federal poverty limit. And then the key emphasis related to low income is that the utility actually has to know that the household is low income, so they have to essentially have information on file of the income status of the household. So it might require, and we do encourage households who are low income status to let their utilities know about that for a number of reasons, including the ones that Lauren has talked about related to the assistance programs. And then this is a moratorium on termination. This is not a dealing with or access to wiping out prior bills. So bills will continue to accrue and do continue to stay there during the winter moratorium. It is a moratorium on terminations for this winter period. And again, it's a moratorium on termination, so that does not mean that it's a guarantee of restoration of service if a person's services are already off when the moratorium begins. Now, that said, the moratorium dovetails and overlaps normally pretty nicely with LIHEAP season. So generally what you'll find for people who do work with utilities in terms of advocacy is that utilities are more willing generally to engage in discussions during LIHEAP season and winter moratorium season. Normally being the key word, Lauren can attest to the fact that that is not always the case as one of the people in our office who does a lot of individual service work. So for those utilities who agree to restore service, it should be restored within essentially 24 hours. If it is terminated for non-payment during that moratorium period. And then in terms of the timing of notices, because the winter moratorium is a moratorium and termination, so affects notices that are sent out, generally with these regulated utilities, you'll see that they start sending out the termination notices, shut-off notices as early as February. And what this does is it does create essentially an overlap period that allows eligible customers to apply for LIHEAP before the end of the LIHEAP season for crisis funds and hardship funds before the moratorium ends, so they can potentially deal and get that additional kind of grant assistance during that period with that termination notice. So sometimes that gives an into some very needed assistance. And then let's talk about some strategies for avoiding termination. We've already given you some base level rules for termination. So the top line that we always recommend and see if it's a possibility for the clients and customers that we work with is see if we can enroll them in a CAP program. And as Lauren mentioned, this is useful because they would get the discounted CAP rates of service, but also because it can potentially help with pre-CAP arrears and help them earn forgiveness on that amount. Now, that being said, there's certain situations in which CAP enrollment might not help the person resolve their underlying either termination issues or underlying arrearage issues. So here are some of the asterisks, if you will. So first, if the customer is currently enrolled in CAP. So CAP rates don't necessarily always mean affordable rates of service. It's something that we work with in the systematic advocacy sense, but there are certain caps that may still be unaffordable to individuals. So they might not be able to afford their CAP bills. And if the person who is enrolled in that program builds up those debts, those arrearages within the CAP program while they're enrolled in their CAP program, they often need to be dealt with through some other means. They cannot be folded into that CAP forgiveness. So you'll normally have to kind of troubleshoot them through some kind of grant assistance. In addition, we sometimes find that customers were previously enrolled in CAP. So this can pose challenges in a number of ways, right? So first, there are certain utilities that only offer essentially a once-in-a-lifetime arrearage forgiveness, unless the initial deferred amount that they were given forgiveness on was minimal, normally under $500. There might be some exceptions that are made. And essentially what that means is if a customer re-enrolls in CAP, they might still get that discounted cap rate, but they might not be eligible for that arrearage forgiveness component. In addition, we were talking about a cap on affordability potential in the previous little section. If you're working with someone who is previously enrolled in CAP, they might still have those cap debts, so debts that were accrued, arrearages that were accrued in CAP. And again, that poses a challenge because they generally are not able to be rolled into that cap amount that can be eligible for forgiveness through that other benefit that Lauren was talking about. And then some other challenges that we generally see that prevent people from getting in CAP. So timing. So if you're working with someone who is facing an immediate issue with termination, there might be a potential where waiting for CAP might essentially get them terminated in the interim. So sometimes there's some advocacy that's necessary to get a hold placed on the account while the CAP application is pending. And then just a big flag, honestly, about suppliers. So for customers who are shopping, right now, as the current state of the Commonwealth is, there is no CAP shopping allowed by any of the regulated utilities. So a customer in a CAP program is not allowed to shop. And this is for a number of good reasons. I could literally do a full presentation of the dangers of shopping and the dangers of CAP shopping in particular. But the big kind of takeaway from this in terms of the practical effects is that a person a customer will not be allowed to enroll in CAP if they are shopping. So if they have a supplier, what they have to do is essentially get it canceled before they can enroll. And it might take a few billing cycles for a supplier to come off of bill. So sometimes this does require essentially the timing advice, the hold to be placed or requested to be placed. And then there could be potentially some interplay with cancellation fees and some other kind of issues. So trying to get that done as quickly as possible is always the key, but sometimes there are holdups with that process. And then company payment arrangements. So we don't recommend payment arrangements as the first stop if CAP is on the table. The reason being what payment arrangements are is they essentially take a back balance or arrearage and they allow it to essentially be amortized over a period of time so the customer is able to pay it back slowly. That's the theory of payment arrangements. So let's talk about the practicalities. So in agreeing to a payment arrangement, a customer has to essentially admit liability so that they admit that they owe a certain amount, the payment arrangement amount, to the utility. So don't enter into a payment arrangement if you're not sure that you actually owe the amount, as the first piece of advice there. And then the period of payment arrangement will vary, and it can vary by a number of factors, including FPL of a household. And it can be generally, we see anywhere from around 6 to 60 months, depending on circumstances, depending on FPL. We'll talk about that in a minute or two. And then the payment arrangement amount, again, allows you to stretch out the past debt over a period of time, but that doesn't get rid of the regular monthly bills. So you're essentially doing current charges plus in terms of a payment arrangement. Again, some of the potential unaffordability kind of interplays with payment arrangements. So there are different buckets of payment arrangements. And if you take one thing from the slide, it's that payment arrangements exist. Well, two things from the slide. Payment arrangements exist, and there are utility payment arrangements and PUC payment arrangements, and they are different. So utility payment arrangements, the kind of big takeaway is that utilities have wide discretion when they're resolving owed amounts. So utilities can offer as many payment arrangements as they want for any period of time. Now, that doesn't mean that you're going to see it for any period of time, but there can be variations. However, they are only required to offer one. Now, with customers who are survivors of domestic violence who have either PFAs, and we'll talk a second again because there's this other amorphous category called other court orders. And I'll tell you what that means in about 2 or 3 slides. But so certain qualifying survivors of domestic violence may be granted additional flexibility related to payment arrangements depending on their individual facts or circumstances and can be granted 60-month payment arrangements, so those longer-term payment arrangements, again, depending on their facts and circumstances. And we'll unpackage that a little bit as well. And then, as promised, there are also PUC-issued payment arrangements. Now, these are more creatures of statute, creatures of regulation. They are more kind of top-down in terms of their structures and what you see in terms of payment arrangements. So you have essentially two buckets within PUC payment arrangements. You have what we call just general payment arrangements, and then you have restoration payment arrangements, so for customers who are already off. So for the big bucket of payment arrangements, for PUC payment arrangements, you are seeing those for customers who are either active or their service has been terminated for less than 30 days. So after 30 days, a customer is essentially considered an applicant. So this is going to apply to customers, like current customers. And then there are different terms, and again, these terms are very much creatures of regulation, but if you're looking at a household who's at or below 150% FPL, the customer will get one, bold one, 60-month payment arrangement, and that's essentially the longest amortization of that period that you can look at. If you're working with a customer who's an applicant, so their service has been off at least 30 days, then you're looking potentially at a payment arrangement for restoration. And if you're looking specifically at restoring at the same address, this might be available to the customer. And again, if they're under 150% FPL, they will get one, keyword one, 24-month payment arrangement, so a little bit more narrow in terms of that stretching period. So the kind of potential interplays, downfalls, if you will, of payment arrangements is if you're working with someone who has past debt, past arrearages that are accrued while in a customer assistance program and a CAP program, they generally are not eligible for those PUC payment arrangements. And generally, the utility will, frankly speaking, be pretty reluctant, as we've mentioned, to give the payment arrangements on their side, so the utility issued payment arrangements. And then the practice tip, or the practical implication here, is that if you're working with a person who has CAP arrears and they're unable to get on a payment arrangement, they're forcing termination, and you're looking at a termination notice and you're oftentimes seeing a pretty high amount, right? Don't assume that entire amount is debt accrued while in CAP. Generally, if you're looking at a termination notice that is lumped in together with, like, all the debt is lumped in together, asking some questions around which portion is pre-cap arrears, which portion is in cap arrears, can help you figure out what you need to pay to get the person back on cap, so the cap catch-up amount, and get them back in kind of that system of getting all the good cap benefits that we've been talking about. And then a flag I've given you a few times, I think, at this point, is that the PUC cannot require utility to enter into a second payment arrangement absent an extraordinary set of circumstances. So these are not indefinite tools. They are pretty limited, and they have to be used in strategic and targeted ways and in a correct manner. So let's talk about some special circumstances around different populations and around certain vulnerable populations as well. So first, let's talk about a little bit more about tenants. We've kind of alluded to different tenant issues throughout this presentation. So if you're working with a tenant, and this is going to be a very kind of special circumstance in which these rules are going to apply regardless if you're looking at those regulated utilities or unregulated utilities in the Commonwealth. So if you're working with a utility and a utility is in a landlord's name and the landlord does not pay for whatever reason, renters do have certain rights. So first, they have the right to be notified of a landlord arrearages 30 days in advance of a termination. They have to then be given an opportunity to pay the last 30 days of charges for that utility service. Now, on an ongoing basis, they should also be given the right to pay the forward charges and then deduct those from rent without essentially taking on the debt of the landlord, the previous debt that they have not already paid through that 30-day charge. There are practically protections from retaliation. We all know on a real world basis that sometimes does require a referral to legal services if you're working with a low income person, if the landlord is not amenable, and there is still attempted retaliation. And as I mentioned, this is going to apply to both regulated and unregulated utilities. There are two different controlling statutes. And if anyone wants me to talk their ear off about this, I'm happy to do so. But essentially, they come from different places, but the protections are mirrored. Now, there is another situation. What happens if a landlord or a property owner is essentially paying, so there's not necessarily a termination on the table, but they are essentially requesting that utility service is terminated to an occupied unit. Now, there has to be either a notarized consent by the tenant, absent an emergency, or there has to be certain rights that the tenant has access to. So, as I mentioned, tenants must be given notice and the ability to keep service on an ongoing basis. The other flip side is if a utility is informed that the residence is tenant occupied and there's been a service termination, there is a requirement that they restore service within 24 hours and then essentially redo the process. So do the process they should have done. So give proper notice, go through that, and make sure that the tenant is not asserting their right or gives that notarized informed consent. And then if the landlord still physically turns off service by, for example, disconnecting a breaker, shutting off water, it is considered a landlord-tenant problem. It is we often refer to housing attorneys for that. It could be considered a constructive eviction. We are not housing attorneys, so I do not make that judgment call. But we do work closely with some housing attorneys that we often refer to if these situations occur. And then let's talk about an even stickier situation, foreign load. So first of all, what is foreign load? So if utility service usage that is registered on an individual meter, so a customer's meter, but it's foreign. So it's essentially provided to another dwelling unit, a common area of the building. So essentially it's a situation where a customer is taking on the charges of another dwelling unit or a common area. Now, what happens in that situation? The tenant has the right to contact a utility to request a foreign load inspection. Investigation, sometimes called. And if through that investigation it's determined that there is in fact foreign load, so the tenant's meter is powering or other areas, so shared common areas, other dwelling units, the utility will transfer the service and any existing balance on the account to the landlord's name. And then the landlord is responsible for that full amount of the residence, that bill of the residence, I should say, until the foreign load issue is removed. And then the tenant is only responsible for paying the utility bill going forward after the foreign load issue is resolved. Now, while the last slide we were talking about both unregulated and regulated utilities, foreign load, these rules, we're going to be talking about regulated utilities. It becomes much harder to navigate in an unregulated sense. Now, let's talk about limited English proficiency households. We regularly work with customers or providers that are from these communities or serve these communities, and it becomes very tricky. And the reason it becomes tricky is that there's not a lot of good rules, regulations, statutory requirements that protect limited English proficiency households. So let me tell you what there is, first of all. Per regulation, it is required that utilities in the Commonwealth include on termination notices at least a phone number and directions so that LEP customers can call for information and translation services in languages, and here's the key part, other than English, comprising 5% or more of the population in their service territory. So generally, a utility will be able to tell you what's on this language list. It is not uncommon, let me tell you, for sometimes this list to be English and Spanish, unfortunately, which is a potential and a huge potential barrier to customers learning about if there's termination on the table, accessing available assistance. In addition, there is a regulatory requirement in Commonwealth for those regulated utilities, again, to provide billing information in Spanish if they serve a substantial number of Spanish-speaking customers. And again, this can get tricky. You generally have to look at what they have on file and what they constitute billing information, right? So it might just be a little blurb on a bill that says, if there's questions, contact the utility, that might be translated. This can, again, cause numerous issues related to bill understandability, bill payment, and all the good things that come along with that, making sure people are getting assistance when they need, right? And then I know I've been kind of alluding to ongoing issues in general, but we do, as an overarching flag, regularly hear from LEP consumers, LEP customers who are having difficulty accessing information and assistance from utilities. There's numerous barriers and roadblocks that can occur through this process. We've been talking about just figuring out what the information is, because there's inadequate translation and documentation assistance, but even things like calling into call centers and whether that is navigable on their end. We run into issues from kind of the lens of our LEP clients all the time, where there's numerous roadblocks throughout the process, unfortunately. And then I'm going to give just really brief information about medical certificate, just to make any of you who might not be aware there are certain protections possibly accessible to customers who are medically vulnerable. So there's this thing called a medical certificate, and essentially what it means is that a household may obtain a medical certificate to delay termination, only to delay termination, if a household has a serious illness or medical condition which requires utility services. So some key things here: the medical professional who's signing the medical certificate ultimately makes the decision whether the condition qualifies under the standard, not the utility. And then there are ways, potentially different ways, that healthcare providers might be able to fill med certs out. They can potentially fax them depending on the utility operations, check with the utility being the kind of the key piece of practical advice here. What happens if a household gets a medical certificate? So as I mentioned, it stops termination. It stops termination for 30 days from the date of issuance. Can a customer renew? Yes. So a customer may submit a new medical certificate every 30 days if they are keeping current and paying their current charges by their due date. Now, if the customer is unable to pay their current charges by the due date, they can still renew a med cert 2 times. So that's 90 days of total protection. But it's not, you can't keep renewing it after that unless they're paying their current charges by the due date. And then the other kind of piece here is that the commission has developed a medical certificate template. A medical certificate should not require a utility form to use. So as long as it has all the required elements, and we're happy to talk here about this as well, but there are certain required elements for med certs. As long as it has the required elements, it can qualify as a med cert. You can use the commission template, you can use a utility template, or it can be on, a doctor's note, if you will. So the specific form of writing is less important than the information in it. And I think we can go to the next slide. And then, as promised, some additional information about victims of domestic violence, survivors of domestic violence. So there are additional utility protections that might be available to certain survivors of domestic violence. However, they are dependent on whether the survivor has and is able to produce either a copy of a PFA, so protection from abuse order, or other court order that contains clear evidence of domestic violence. And this can become really tricky, right? This other category, what might fall into that bucket, particularly because there is no charge for domestic violence in Pennsylvania. So there are kind of questions around that. We're happy to give you some additional information to help you navigate if you run into some of these situations. What happens if you have a qualifying survivor of domestic violence in terms of these utility protections? First, the survivor, the victim, cannot be held responsible for debt accrued in anyone else's name, even if they lived at the residence when the debt accrued. Now, this is considered an exception to almost golden rule in utility practice in Pennsylvania, which is called occupant liability, which is exactly what it sounds like. It means that an occupant may be held liable for utility debt at that residence. So this is an exception to that rule. And essentially what this is meant to memorialize is that survivors should not be taking on the debt of households, especially of their abusers, once they're trying to relocate and reestablish their lives. Now, there's other flexible payment arrangement standards that might be accessed for qualifying survivors of domestic violence. Sometimes, depending on the facts and circumstances, they can access 60-month payment arrangements, but again, it requires the information to be on file. And then we've talked about this. I'm not going to belabor this too much, but just a reminder, there is an additional notice provision for qualifying survivors of domestic violence. There's that additional 48-hour notice if that attempt at personal contact at last knock is not successful. And I believe go ahead.
I was just going to say, I just wanted to add some of my personal experience with like direct representation in this area. I have had utilities accept like a victim advocate statement. I have had them accept other things. I think they would generally accept if there's a custody order that has, a clear mention of domestic violence or reason for custody. So in my experience on the one-on-one level, they're willing to be fairly flexible, but you never want to assume. But I think if there's anything, it's worth pursuing if you think there's a benefit. All right, so we are going to talk a little bit about disputes. You'll remember when Ria was talking about payment arrangements, the very bolded, underlined, undisputed debt. We don't always think the debt is undisputed. Sometimes you may want to dispute that debt, and it may have to do with a foreign load issue. It may have to do with a meter you don't think is. It could be any reason. But here's what we deal with for disputes. So, initiating a dispute. You have to first initiate the dispute with the utility. The utility has an obligation under the commission regulations to address disputes. The customer also has the obligation to give the utility a chance to resolve a dispute before going to the commission. If a customer goes directly to the commission, they're going to ask them, just like I do when people call the hotline, is when was the last time you talked to the utility company and what did they tell you? They said, well, I haven't called them since they shut me off. Well, you have to do that first. So, and some tips here to make it clear that you are initiating a dispute. Use the magic words, I'm disputing, or no, my issue has not been resolved. And this can be for a lot of reasons. It may not simply be that these aren't my charges, these are someone else's charges. You may be disputing that the payment arrangement that they're offering you is reasonable. You may be disputing, so the dispute can be largely broad, but you just want to be super clear. You can request a utility report or account report if you think something's screwy with payments. Sometimes it can take a while to get one of those, but you can request it. And you do have to continue to pay any undisputed bill. So this is an area that people do get into trouble. They think if they're, having a fight with the utility company, they're just not going to pay anything until it all gets resolved. That's not how it works. That you have to continue to pay your bills going forward while the disputed amount is being dealt with. So let's say, they've reached out to the utility and we're not satisfied with the result that they got, or the utility says, nope, what we told you, that's what we're going to do the end. We don't have to do anything else. The next step would be to file an informal complaint with the commission. This can be done over the phone. It's a very brief online form. It is not an onerous filing. It is very straightforward, very simple, plain language. There is a timeliness component, so 3-year statute of limitations. Typically, people are filing things as they're getting shut off notices, so it's not, that I've never really seen that come into play. I'm sure it does, but not for this sort of thing. For an informal complaint to delay a termination, it has to be filed before you're shut off. So if you get a shut off notice and you're like, there's no way I can pay this, and they should have offered me a better, and they wouldn't give me a reasonable payment arrangement, that file the complaint. And if you file it before the day on the termination notice, you cannot have your service terminated for that debt until the situation is resolved, as long as the complaint takes to process. It may take 4 to 5 days, or it could take a couple months. It really depends on what you're filing the complaint about. Typically, they do process fairly quickly, so you're maybe looking at a week. And at the informal complaint stage, unless the utility did something like blatantly against the regulations, the outcome will likely, best case scenario, is going to be a payment arrangement. And the commission, as we talked about commission payment arrangements. If you have cap debt in your balance, you're not going to get that payment arrangement. If the utility has already given you a couple and you haven't been able to make any payments in the last 6 months, you may just not get one at all. So practical tips here: stay engaged, follow up on the complaint, get to know the investigator. I will say I used to work in fair housing, and we helped clients with PHRC complaints. And so I got to know my investigators, and I really liked a lot of my investigators. Maybe some of them are on this call, who knows? That was some time ago. And just provide you have to advocate for yourself as a customer. I mean, if you've had medical issues, if you've had a death in the family, if you've had situations around domestic violence, this is all relevant information, and you need to be willing to advocate for yourself in these disputes. So let's say you file your informal complaint and the commission says, sorry, there's nothing we can do about this. If you want to take it another step, you do absolutely have appeal rights. Formal complaints. Those would be heard by an administrative law judge, and the decision would be reviewed by the commissioners. And to appeal that, you then go to Commonwealth Court. So sort of similar to the internal PHRC process that then can appeal. When you get a decision, the commission will send the paperwork for the formal complaint. It's not quite as straightforward as the informal complaint, but it's still, I think it's pretty accessible. So you do have time limits there. And then we don't typically represent clients in formal complaints or informal complaints. That's not to say we can't. I think if something came along that we really wanted to have a fight about, and we're sort of about to have a fight about something, then we can do it. But typically, most people that call our hotline, they're not disputing their balance. What they're disputing is that that's affordable for them. And usually they're right, it's not. So, complaints can sort of serve a lot of different purposes. If something like this comes up and someone's working on one of these things, you have some questions about it, I'm always happy to have a conversation to sort of say, oh yeah, this is what happened. This is why you got the decision that they did. While the complaint process is going on, you can still negotiate settlements with the utility. I think utilities, kind of want to settle things. I mean, they don't want a lot of decisions against them. They don't want a lot of formal complaints filed against them. And to that end, when I see people with systemic issues, that I think their issue is part of a bigger systemic issue that I think maybe there's not what I think is not adequate regulation on, I want them to file those complaints. I want them to get that on the record. I want the number of those complaints to, to sort of be there. And I think that those individual actions can, have larger results. But again, you do need to be a licensed attorney to represent a client before the commission for a formal complaint. But again, we don't represent clients before the commission generally, but we can still provide information about how the process works, what their rights are, and that sort of thing. So we have a lot of referrals here, so I'm going to talk through them to tell you why everything is what it is. So for Pulp, up at the top here, for any questions that anyone on this call has, you can email pulp@pautilityLawProject.org. That goes to all of us. You can also email me directly if you want. My email is on the front of the thing. On the front of the PowerPoint. We do also have a hotline. However, we have very limited capacity and things have been very expensive over the last year, as some of you may have noticed. So we have had an influx of clients and it's been a bit overwhelming. So my ask, I guess, is if you have people that you think are appropriate referral to us, feel free to just send me an email personally or email Pulp. We are happy to talk about the situation and maybe something that we can provide some technical assistance that you can pass on to the client, or it may be something that I think we should probably handle that, in which case, I'll have you refer to us, and that's totally fine. That's the only reason I don't have it on there, is because we have limited capacity and I don't want to overwhelm ourselves.
Lauren, I'll also
Yes.
note that our hotline is closed through the holiday weeks, which is another reason that we're not immediately pushing out the information. However, if anyone wants more information related to the hotline, we're happy to engage in that discussion, because we do have certain pathways that we send people down in terms of technical assistance as well, to make sure that we're getting them the best help that we can kind of possibly get within, the fact that we are a staff of 9, essentially.
Right. Yeah. So again, we want to know what is happening. We want to know what you're running into. It's just we're not going to handle everything through the hotline. So email me, email Rhea, email me. Rhea's very busy. She works on a lot of bigger litigation than I do.
It's fine to email me as well. Lauren might know more about the individual issues, though, because she is one of our experts who runs our direct services. So she is very good at what she does.
I do a lot of it. I don't know, call it, I do a lot of it. So for the one exception, though, so we are statewide, except we do not take individual clients in Philadelphia. We refer all of those clients to Community Legal Services. They have an excellent energy unit that does the same work that we do. So if you have someone in Philly that would not come to us, they would go straight to Community Legal Services. We have the Bureau of Consumer Services, again, the number for informal complaints, information about filing formal complaints. And then I included the Pennsylvania Attorney General's office here, and this is sort of a recent development. They've been very interested in housing condition issues, and specifically around rights for people with unregulated utilities. Most of the time, you're talking about municipal water authorities, of which there are thousands in Pennsylvania, and they are very lightly regulated. We individually have had a very difficult time in certain circumstances getting the municipal authorities to recognize people's tenants' rights. So if you run into those sorts of issues where, the landlord stopped paying the bill, the tenant got shut off, the municipal authority won't turn them back on, won't give them notice, won't let them pay just the last 30 days. Again, they should never be taking on the debt of the landlord. If you run into those issues, those clients should be filing complaints with the Attorney General's office. They are interested in these complaints. You can also give us a heads up about them, because we have very good contacts regionally. So we can flag those complaints once they're filed to make sure that they get handled timely, especially, again, water is a requirement. So, you don't want those things sitting around for weeks and weeks. So file the complaint, contact us, we'll make the connection and raise up that complaint. So for unregulated utilities, I think the PA Attorney General's office has been a really good resource lately. So we encourage you to get people over there as appropriate. And then this is just a link of resources. So the top one here, we have regional one-pagers with program information. We have tenants' rights guides. We have, oh no, I got a shut off notice, what do I do? So we have a lot of that information sort of in easily digestible format. That's a link to the LIHEAP page for DHS that has all the information on there, including the state plan, universal service, contact numbers. I don't know that you would need to use those so much. We also have the universal service plans. So those are the plans that every regulated utility files every, I think, 5 years for their universal service plan. So these are very dense documents, but there's a lot of information there. And then we also linked again to the medical certificate form. So I am going to, if I can figure out, yes, end slideshow. And I will also stop sharing my screen if I can figure out how to do that.
And Lauren, I'll just clarify, regulated water utilities are not required to file plans. So you will not find any of those on this page because they do not exist.
Great note. So again, we're going to send the PowerPoint to you all, and so you guys can disseminate it. So you'll have all of these links. You'll have all of our contact information. So, use it. We want to know what's going on.
Lauren and Rhea, thank you so much for this information. This is great information. I particularly liked the foreign load, because is something that has come across in my previous career, where landlords are pretty slick. Some landlords are pretty slick with that, and the foreign loads. Next thing you know, somebody is paying for water, for example. There was one particular case. where the water is being cut off, and she noticed a sudden increase in her water intake, yet her usage had not changed.
Mm-hmm.
And so then she found out that there was something going on where the landlord was using a lot of water for a project, but it was coming off of her meter.
Yeah,
Uh,
it's
and
very common, and sometimes it's not intentional. I mean, we have there's a lot of old housing stock in Pennsylvania that has been converted, and so you never know what wires are going where.
Yeah.
So it's not. I mean, oftentimes it's intentional, but oftentimes it's not. I mean,
Right.
oftentimes it's just this has been a weirdly wired house, and we just splitting up into units, and now we're renting it out, and who knows who's doing what. So
Exactly.
you know,
Exactly. Yeah.
it's very common.
Who pays for the hallway light that is always on? You know, in those converted
I paid
homes.
for that hallway light. I too have been. I paid for that hallway light in my last place.
So, but I mean, you know, again, it's important to know, because, you know, one of the questions that I asked our chief counsel is, hey, would you say that this is something that falls within the public accommodation sphere? And I think that if we take a look at our PHRA and we analyze it and we interpret it as liberally as possible, I would say, yeah, it certainly is. But I'm not the attorney. I leave that to the chief counsel to decide. But thank you so much for that information. And with the time that we have left, does anyone have any questions that they want to ask our invited speakers today? I didn't see any in the chat, but I wanted to offer that opportunity.
Yeah, I didn't either, but I will say it's a lot of information. So it may be something that, like, in a couple days from now,
Sure.
someone might say, actually, I had a question about that. So
All right.
I do want to encourage everyone to reach out liberally. I'm always happy to handle technical assistance questions.
Thank you again, both you and Ria, for this great information, and thank you all for attending. We like to have these discussions because I have always believed, and I know that Director Eyster also believes, that anything in and around housing needs to be looked at and analyzed and put under the lens to see if there's a propensity or a possibility of violating somebody's housing rights. So that's the reason for having this session, and we'll be providing others on other topics as well. Thank you again. Thank you all for attending, and we'll see you next time. Thanks.
Thanks, Adrian. Thanks everyone for inviting us.
Thank you. Bye.
Bye.
Bye.